Good morning. Are you Samuel Jones?
This group.
And this is cause numbers 25 DCCR 0043 and 0232. Mr. Jones is charged with burglary of a habitation and burglary of a building. Last year, Mr. Jones was found not competent to stand trial and was sent to the appropriate facility for competency restoration, which was the Dunn Behavioral Science Center. We've received the trial competency evaluation report from them. I'm going to take judicial notice of the court's file. The opinion at this time is that Mr. Jones has not regained competency at this time and that further treatment would be required. Hold on, let me get to it. So the further inpatient treatment would be required for competency restoration. Is there any other evidence with regard to competency?
No, Your Honor.
Mr. Smith. Then at this time, I'm going to find that Mr. Jones is still currently not competent to stand trial, that further treatment inpatient for competency restoration is indicated, and order that Mr. Jones be committed for a period of not to exceed 1 year for competency restoration at this time. If competency is achieved before then, they'll let us know and we'll get Mr. Jones back and move forward with his cases. All right, Mr. Jones? Keep doing, it sounds like you're getting better and you're taking your medication that they're telling you to take. And so you're on the right path. Keep doing everything that you're supposed to so that we can get you back here and get you taken care of. Okay. All right.
Thank you.
Yes, sir.
Okay.
It's February. I mean, yeah.
Judge, just tell you what I've done. I've reaffirmed the last offer I made with Mr. Burbank, which was 12 to Ms. Prozo. I think it would help if she had a little time to talk to him.
Yeah, that makes sense. I knew it had been going on, and obviously it's not your fault that the case has been going on for a while. And so I'm going to ask you to do the best you can.
Yes, ma'am.
To kind of stop talking.
Okay, I didn't go for that.
So, Mr. Hill, we've gone over this before. If I'm talking, you don't talk because this lady's taking everything down and she can't type us both at the same time.
I'm just trying to defend my right.
Ms. Perazo,
For 17 times.
I understand that.
Fine.
I'm tired
I'm
too.
very tired.
Me too. Trust me. We're going to get your case taken care of. Ms. Perazo is going to get on board as quickly as she can. She's got a lot to go through in a short amount of time, but she's going to do that for me. And so that we can get your case moving in the correct direction very quickly. Give me just a second to look for something. Okay.
And
I don't see.
I don't think we ever did a full injection of that. And it really doesn't matter for today, Judge, but
So what we'll do, I don't see that there was a formal rejection done. So visit with Mr. Hill about what the offer is. It is what it is now. Doesn't matter what it's been in the past or what you think it's been. Mr. Hill, Ms. Perazo will get an offer from the state. If y'all want to reject that at the next court date, let's get that taken care of and we'll get it on the trial docket if that's what it needs. Otherwise, we'll get it taken care of at that next court.
Okay,
Thank you,
thank
Ms.
you.
Perazo. I appreciate you getting up to speak quickly.
thank you.
Good morning. Are you Teesha Johnson?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Johnson, in cause number 20-34671, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 9th of 2020 for the first-degree felony offense of aggravated robbery, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation in count 1 by failing to report as directed to the probation department February 2nd of 2026. And is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 2.
Hold on, this is where things get serious. She's not fighting the allegations. She's admitting them. In legal terms, pleading true means she's basically confirming she violated probation. Now the real question is, does the judge show leniency? Or is this where everything falls apart?
Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? And then count 3 alleges that you're behind in your court assessed fees as of February 3rd, 2026 in the amount of $5,684. Is
Yes,
that
ma'am.
true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you go over these with Mr. Parker before you signed them?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And it looks like the agreement that's been reached is for you to remain on probation, but for me to order that you enter and successfully complete the cognitive track of the NSF program. Is that your understanding?
Yes, ma'am.
And Mr. Nichols and probation, y'all are all in agreement and think that's the best thing?
Yeah, sure.
Okay.
Just for the record, Judge, she's had some health issues and had some surgeries, but she's also just got her commercial driver's license, so she's going to be able to make some money and pay back her rest her fees.
It's very important that you do everything. Show up, don't miss any appointments and things like that. So,
Yes, ma'am.
because I mean, the violations aren't terrible, so I understand the agreement. I also want to make sure you understand the underlying offense is bad. And so this is your opportunity to make sure you get everything in order. You don't miss any appointments. You get to get a job, start paying back on those fees. Because if you don't, then things could be a whole lot worse. We're not going to be back in here doing the same thing again, okay?
Yes, ma'am. Thank you.
All right, so I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true, find sufficient evidence.
Right here is a massive break. The judge could have revoked her probation and sent her straight to prison. But instead, she's getting another chance. That cognitive program? That's not optional, it's her lifeline. Mess up again, and this story ends very differently. So what do you think? Did she deserve this second chance? Or was the judge too lenient?
Sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow this agreement, continue you on probation in order that you enter and successfully complete the cognitive track of the ISF program. As soon as you get out, you're still on probation, you go straight to probation and get going back where you need to be, so that we don't have any issues, okay?
Okay. Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. Good luck.
Thank you
You can
so
go back with the bailiff. Thank y'all for being here.
Thank you.